Your Honor, the other side would have you believe that when two parents aren't getting along that their rights are up to this court.
Counselor, I am going to let you make your argument, but please be brief.
The other side is asking this court to infringe the fundamental rights of this man and his children. It is absolutely clear that the state may not deprive a fit married parent of their rights to their children in this manner. And it is equally clear that the state may not deprive this father or his children of these fundamental rights based on his marital status either. That means divorce cannot be the justification for doing so. Therefore, we are asking this court to establish its constitutional justification for classifying this parent as a fit parent whose rights may be denied in this way. We assert that since fundamental rights are at issue here, that this court understands that the Equal Protection Clause from the 14th Amendment applies. This means that strict scrutiny applies and the state must show its constitutional authority to act under strict scrutiny.
Are you about done, Counselor?
Just about, Your Honor. Please just give me another minute, Your Honor. I understand that this may be a novel argument for this court. However, this parent is raising the issue of protection of his and his child's rights, and therefore the court must consider his argument.
Oh God, why can't people just cooperate and move on?
Pardon me, Your Honor.
Nothing, never mind. Continue, Counselor. But make it quick, I have a full docket and there are other people waiting to be heard.
What this means, Your Honor, is that we expect that this court will use all 5 parts of the strict scrutiny requirements before infringing or reducing any of his rights.
Counselor, is all of this really necessary? I followed the family code statutes in this court and you know this.
Yes, Your Honor, that is why my client wants this issue addressed. He is objecting to the family code statutes being applied to him and is objecting on the grounds that those statutes violate his fundamental rights because they do not apply these 5 steps. If you allow me to continue, Your Honor, I believe that you will see that this is appropriate for this case.
If you must, Counselor, then proceed.
We are asking this court to follow these 5 steps. Number 1, switch the burden to the state and the other side. Number 2, show a compelling interest. Number 3, show a necessity to act. Number 4, show that the statutes you are using are narrowly tailored. And number 5, show how this is the least restrictive means. In addition, Your Honor, this court must try the least restrictive before the court can decide that it does not work with these parents. And the test for measuring whether or not it works is not whether or not the parents get along, but rather if one parent is interfering with the other parent's ability to exercise their rights and time with the child.
Now are you finished?
Just one more thing. Also, the court may not burden the exercise of these rights through the ordering of custody evaluations, guardian ad litems, or other expensive and burdensome interrogative fishing type of explorations.
Then how do you propose I figure out what is in the best interest of the child, Counselor?
Very nice performance, Counselor. However, Your Honor, they are forgetting about the most important person in all of this, the children. And the court must act in the child's best interest and not in the parents' interests. They are forgetting about the most important person in all of this, the children. The court must act in the child's best interest and not in the parents'. The mother is asking the court to decide the best interest of the children, and because the parents are in disagreement with what that is, the court has the authority to make this decision. In fact, you are required to make this decision by statute.
Your Honor, again, we do not believe that is what the court should be addressing here today. And we will show you that by protecting this father's rights from the attacks the mother is making on his rights here today, that you will be protecting the child as well. The child has 2 fit parents. Whether they disagree with each other or not is not how the court should decide that it gets to take over the rights of the child to be protected by each of his parents. We believe that the court should address whether it should protect both parents' rights equally, since there are no proper charges before this court regarding any child abuse or endangerment. Therefore, the court must presume that both parents are fit and must protect my parent from attacks on his rights from the other parent. Your Honor, if the court disagrees with us, we are asking for enumeration of specific statutes that this court believes authorizes it to create this classification of parent and to show that the statute is narrowly tailored on the record.
If you are done, Counselor, I would like to take a moment to look through your motions.
Yes, of course, Your Honor. But may I just finish? Ms. Green interrupted just as I was wrapping up the three questions that my client would like this court to address before proceeding.
You may, but make it quick.
Yes, Your Honor, will do. The equal protection motion is addressing one thing, and that is the application of the 14th Amendment due process clause into this family court proceeding. The questions that we believe the court is being asked to address today is, number 1, do fundamental rights determine the level of procedural due process that is required? Number 2, what is the classification that you are depending on to treat these two parents differently than other fit parents? And number 3, what is this court's compelling state interest?
Thank you, Counselor. I will take a few minutes to review the pleadings now.